take it away.
Thank you, Sansara. I wanted to speak a little bit more about what I briefly mentioned last Saturday at the steps of the Supreme Court when I was speaking about how Roe v. Wade did far more than establish the right to abortion. I think it's very important that we all understand that in terms of the repercussions that could occur and how it can affect others' basic civil rights if Roe v. Wade were overturned as well. Okay. Specifically, it solidified and expanded the constitutional right to privacy. Very important, which has also been described as the right to autonomy. This right to privacy is part of the right to liberty protected by the 5th and 14th Amendments, which state that no person shall be deprived of life, liberty, or property without due process of law. The Constitution's protection of liberty and privacy underlies the Supreme Court's recognition of fundamental rights related to contraception and procreation, marriage, family relations, child rearing, and intimacy. Although the Supreme Court's recognition of the right to privacy predates Roe, Roe is an important affirmation of and foundation for a broad array of privacy rights. While not exclusively dependent on Roe, Roe influenced privacy principles in each of these areas, principles that could be undermined if the Supreme Court overturns Roe. So, marriage equality, contraceptives, certain fertility treatments, and even interracial marriage are imperiled because they're all rooted in the right to privacy. So here are some examples of how Roe reaffirmed prior decisions. 1, the right to contraception and the right to procreate. Roe reaffirmed prior decisions protecting individuals' rights to contraception and to decide whether to bear a child. Subsequent cases upholding the right to contraception, in turn, rely on Roe. For example, a 1977 Supreme Court case overturned a law that restricted distribution of non-prescription contraceptives to adults and prohibited the sales or distribution of contraceptives to individuals under the age of 16. The case explicitly relied on Roe for its central holding that, in quotes, the Constitution protects individuals' decisions in matters of childbearing from unjustified intrusion by the state. Now, the right to marry. In the Loving versus Virginia case, it acknowledged the constitutional right to marry, and Roe affirmed that it is among the fundamental liberties protected by the right to privacy. Okay, that keeps coming up. Subsequent cases protecting the right to marry have relied on Roe as well. For example, a 1978 Supreme Court decision upheld the right of single parents obligated to pay child support to marry without first obtaining the permission of a judge, and based this conclusion in part because of Roe. This same fundamental liberty right was reaffirmed as recently as 2015, when the Supreme Court, in a case, guaranteed same-sex couples the right to marry. Another right, the right to maintain family relationships. Okay. For example, the Supreme Court relied on Roe, again, to hold that the state cannot interfere in the realm of family life by preventing close relatives from living together. As the Supreme Court put it, the challenge zone regulation, which banned a grandmother from living with her grandson, sliced deeply into the family itself by selecting certain categories of relatives who may live together and declaring that others may not. The Supreme Court went on to say that courts used Roe to consistently acknowledge a private realm of family life which the state cannot enter. Then there's the right to make decisions about how to rear one's children. The Supreme Court has relied on Roe as important support for the proposition that a person's decision whether to bear a child and a parent's decision concerning the manner and rights and responsibilities concerning the manner in which a child is to be educated may fairly be characterized as exercises of familial rights and responsibilities, and thus protected by the Constitution. While these rights related to parental decision-making were recognized before Roe, Roe relied and strengthened the underlying principle that parenting is best when free from unwarranted government intrusion. And then there's the right to intimacy. Another privacy right profoundly influenced by Roe is the right to form intimate relationships and the related right for adults to engage in consensual sexual relations in private. This right was first recognized in 2003 decision striking down laws that criminalize same-sex intimate activity. The case proclaimed that Roe recognized the right of a woman to make certain fundamental decisions affecting her destiny and confirmed once more that the protection of liberty under the Due Process Clause has a substantive dimension of fundamental significance in defining the rights of the person. Such an autonomy in decision-making about intimate relationships was made very clear. And lastly, the right to personal control over medical treatments. For example, the Supreme Court in 1990, influenced by Roe and a liberty interest doctrine, extended the privacy right to include the ability to appoint a healthcare proxy and refuse unwanted medical treatment. The Supreme Court later confirmed that Roe recognized the importance of receiving medical intervention. Were Roe ever to be overturned, it would have ripple effects beyond the right to an abortion. As privacy cases have recognized, our laws and tradition afford constitutional protection to personal decisions relating to, among other things, marriage, procreation, contraception, family relationships, child rearing, and intimacy. So any challenges to Roe threaten the protections for these most fundamental decisions. Some justices have already pointed to several ways they may reinterpret the Roe V Wade decision. Justice Clarence Thomas has already said that he is skeptical there is even a right to privacy, and has been swayed by the lack of an explicit reference to the right to the Constitution. Also, in the 2017 case, 3 conservative judges, led by Justice Neil Gorsuch, argued that states could restrict birth certificates of same-sex parents. He argued there appeared to be nothing unconstitutional about a, in quotes, biology-based birth registration regime where only one same-sex parent would be listed on the certificate. So these are really good examples of how they have already dismantled Roe piecemeal by piecemeal and incrementally could be applied to all of these other rights. Have I said enough?
Great. I'm going to join with the visuals of other people clapping. That was very wonderful. And
Unfortunately true. Yeah.
Yeah, no, it's horrible, Lori, but it's a wonderful presentation of it. And I think it's not just a moral connection between these different, the rights of different oppressed peoples and different forms of injustice. There is the legal underpinnings. I thought you put that together very well. If there's questions, we'll come back to them. I know that there's at least